despite the fact that all parties have closed their cases at the Presidential Election Petition Tribunal. Atiku Abubakar, the candidate of the PDP, is still making moves in the United States to unearth the real records of Tinubu at the Chicago State University. Remember that Tinubu's counsel tendered his Chicago State University records in evidence, but Atiku is not satisfied with it. That's why he made this new court filing in the United States through his counsel, Angela Louis. Atiku is seeking new documents from Chicago State University under subpoena. Atiku wants the court to give him record of Tinubu's admission and acceptance in the university, his dates of attendance, and the degrees and awards he obtained from the university. Atiku told the court that he wants to test the truth and veracity of Tinubu's assertions at the court in Nigeria, that he wants to verify the authenticity of the documents that Tinubu submitted before contesting for the presidential election. This seems very straightforward. Anyone that has nothing to hide will not object to providing more information to prove that actually what he submitted were the correct documents. It's not hidden that it was him that actually attended the Chicago State University in the 70s. Even if the university has an obligation to inform Tinubu before furnishing Atiku the documents, if Tinubu has nothing to hide, he wouldn't object. Although in this case, being under subpoena, the university doesn't need his approval before they comply with the subpoena. So one would expect that it should be simple. You submitted documents. I want to verify if truly these documents aren't forged, that they came from Chicago State University. And the normal process, the person goes to court to subpoena the university to provide the documents. At this stage, Atiku should get the documents, right? No. Tinubu doesn't want him to get those documents because definitely he has something to hide. Because if he doesn't have anything to hide, why did he hire an attorney to block the subpoena? Yes, we'll get back to what the attorney told the court. The revelation about the gender of the Bola Tinubu that was admitted to Chicago State University in the 70s was made many months ago by Nigerian investigative journalist David Hundeyin. This was before the presidential election. So Atiku should have capitalized on this, got all the information he needed, just like Labour Party did. It's just that Labour Party aren't focusing on his university records. They're only focusing on the narcotics proceeds forfeiture he made, the $460,000 he forfeited to the US government. So they got all the information they needed, the judgment, every document relating to the forfeiture. They assembled everything, kept it down, waiting for the Presidential Election Petition Tribunal to start so that they will use it to nullify his candidacy. Atiku should have done the same thing. He should have gotten all the information through subpoena. He should have gotten the records, because the university can't say the records they gave David Hundeyin will be different from the one they will give Atiku. That's not possible. He should have gotten all this. If he had tendered all this, there will be no way for Tinubu's legal team to counter them. Just like his Guinean passport, Atiku also brought that to court. They should have sent someone to Guinea. How much will it cost them to go to Guinea and obtain all the records, notarize them, make everything official? His ally is no longer the president of Guinea, so it should have been easy for them to get everything they need from that country, so that when they tender them, no one can say, this was downloaded from the internet, this is hearsay. They will just knock it off based on technicality. But when you do everything the way it's supposed to be done, that the documents came from the government of Guinea, which will prove that it is real, that it wasn't just downloaded from the internet, that the passport actually exists. With that, no one can prove you wrong, and the court will establish that indeed Tinubu lied in his INEC form, that he had no other nationality apart from Nigerian nationality. Which of course, you know what it means. If that is established, that will amount to instant disqualification. Now, let's see how Tinubu responded to Atiku's subpoena through his counsel, Victor Henderson. He told the court to strike off Atiku's request because no court heard and granted the order that based on Rules 219 and 137 of the Illinois Supreme Court rules, Atiku's petition was invalid because they gave only 6 days for compliance instead of the normal 14 days. In this case, what happens? Because obviously Tinubu's attorney is looking at technicality. They don't want to comply with the subpoena. If they have these records already with the university, they can supply the information needed under 2 days, not to talk of the 6 days. And will the judge agree with them? The judge can simply extend the days to meet up with the rules that he complained about. Since they gave 6 days and it is less than the 14 days mandatory, the judge should just extend it so that we will see the truth. Although the truth is already known, but in this case, let it be the candidate in the presidential election that is obtaining the information from the Chicago State University himself. Even if Atiku can no longer tender the evidence in court because all parties have closed their cases, but it will still serve as a reminder to Nigerians that truly the claims that Tinubu made in his INEC forms were false statements. It's a pity that Chicago State University seems to be helping Tinubu to conceal the information, because if they have these records, why is it taking them time to supply them to Atiku? It's simple. We want to know who this guy is, because the first information that came out from the university when the David Hundeyin made the request showed that the person called Bola Tinubu that was admitted to university had a female gender. And we know that that's not the Bola Tinubu we know today. So it's simple. Let Nigerians know the truth. If someone wants to serve people, the people that he wants to serve deserve the right to know who the person truly is. They deserve the right to know his date of birth. They deserve the right to know his childhood friends, how he grew up, all his history, like other past presidents. The more he continues to hide information, the more it arouses curiosity. Why not just come out clean? Tell us so that we can stop. Because if he refuses to tell us, people will continue to dig. They will continue to dig into his past to know truly who this man is, what he did in the past. You know, a lot of information. One last thing to know is that in the eyes of the law, when a party is blocking evidence, they are suppressing evidence, they don't want people to see the evidence, the court will now become prejudicial. They will assume with prejudice that the information the person is hiding will be injurious to the person. For instance, INEC, they dodged subpoena. They refused to deliver all the documents required of them, despite a court order. On the other hand, they have come to court in one of their replies. They said that Labour Party failed to prove that they won the election. So truly, they suppressed information, they refused to provide evidence despite a court order, and now turns around and say, the person couldn't prove his case. So they are just playing the court, playing with the laws, feeling that nothing will happen, no consequence, that they will get away with it. That's why a lot of amendments to the Electoral Act are needed going forward. Not just to change how we conduct the election, but also to give more powers to the election tribunals. Because how can they give an order, issue a subpoena to someone and the person refuses, they can't do anything? The court even goes to the level of giving excuses for them that the subpoena should have been served on resident electoral commissioners, not the headquarters or whatever they meant. But it shouldn't be so. INEC is one entity. When a subpoena is served on them, they should be able to get to the location where the materials are. If they are demanding documents from Sokoto, Lagos, Akwa Ibom, Borno State, they should be able to get it. It's one entity, it's one institution. So we'll keep you updated on the latest move by Atiku Abubakar to find the truth in faraway United States of America, whether the court agrees with Tinubu's attorney to strike off Atiku's petition, or whether the judge will extend the days for compliance. Thanks for watching.